Good evening, everyone. Good evening, everyone, and I want to welcome you all to the second day of our professional lecture series on citizenship law and practice before the Foreigners Tribunals, organized by the Assam State Legal Services Authority and Parichay Legal Aid Clinic. For those of you who were not there in yesterday's session, I want to give a brief introduction to this program. So, this is the second day of 4 sessions that have been organized by the ASLSA and Parichay, focusing on issues on important questions of citizenship determination and practice before the Foreigners Tribunal. The aim and focus of these sessions is to enable lawyers to practice more effectively and to provide more effective legal aid to their clients before the Foreigners Tribunals, so that no person has the citizenship rights or the right to effective representation be disregarded. Today's session is going to is going to be led by Advocate Zakir Hussain, and it is going to focus primarily on acquiring drafting skills in FT cases. Advocate Zakir Hussain is going to take us through some of the crucial skills that are important for effective drafting at the FT level, which also has implications for High Court cases and High Court writ petitions. A quick introduction to Parichay. Parichay is a legal aid clinic that was set up in 2019 to assist lawyers practicing before foreigners tribunals in Assam. We understand that accessible and quality legal aid is crucial to ensure that all litigants get a fair chance to defend their citizenship status. Parichay provides litigation and research support to lawyers, conducts research in the area of citizenship law in Assam, and our goal is to strengthen the institutional capacity of legal aid systems in the area of citizenship law. I am Darshana Mitra. I am accompanied today by my colleagues Rupali Samuel and Shardul Gopuskar, as well as the many students who are associated with Parichay's work and who continue to assist lawyers in practicing before the foreigners tribunals. Before I hand over to my colleague Shardul for moderation for today's session, I want to quickly take us through the house rules or the some sort of housekeeping rules for the session for today. So the session will be taken by Advocate Zakir Hussain, and the lecture part of the session will last for 45 minutes, after which we will invite questions from the audience. Questions may be either put in the chat box. You will see that there is a chat box on your right hand side if you're looking at this on a laptop, and on the below of your mobile screen if you're looking at it on your mobile phone. You can either type your questions in the chat box. Otherwise, there is also a raise hand option. If you look at the reactions button, there is a small smiley on your screen which is called reactions. And if you press on it, there is a raise hand option that comes up. You can raise your hand, and then when the question answer session comes, then Shardul will come to you and ask you to ask your question after unmuting yourself. We request everybody to please mute yourself throughout the session, because otherwise the sound may cause interference. But of course, when you're asking a question, please feel free to unmute yourself. You will have to unmute yourself. You can keep your video on or off, whatever you're comfortable with for the duration of the session. For those of you who have not attended yesterday's session or who have not given us your email ID, I request all of you to please send us your email ID and or phone number. My colleague Ritvik will be circulating a Google form on the chat box. There you can click on the Google form and enter your email ID and phone number, and that will help us to send you the materials for today's session. Through the session, as Advocate Zakir Hussain takes us through different case laws, we will be sharing our screen and showing you extracts from the case law on the screen, so you know exactly at which point of the case he's referring to. And we'll also be sharing the link to the case on the chat box. So if you want to open it separately on your mobile phone or your laptop, please open it. Then you can read as along with our resource person. Lastly, I request you to please participate. Please ask as many questions as you can. Questions about practice, questions about problems that you're facing when it comes to drafting specifically, and all other questions that may arise. Before I finish my introduction and I hand over to my colleague Shardul, I want to mention that this session would not have been possible without obviously the support of the Assam State Legal Services Authority, who have been extremely helpful and extremely supportive and extremely enthusiastic in their participation in these trainings, and without whose support and encouragement we would not be able to conduct these trainings. Obviously, it goes without saying that without the support and involvement of His Lordship, Honorable Justice N. Kotiswar Singh, who has constantly been an important part of the planning of these sessions would just not have come into existence. Justice N. Koteshwar Singh has tried to and has assured us that he will try to attend some of these sessions, but unfortunately, he's a little unwell, which is why he's not being able to attend the sessions. I also want to acknowledge that we have with us today our resource person from yesterday, Advocate A.R. Sikdar sir, who conducted a very interesting and invigorating inaugural session yesterday on preliminary challenges to jurisdiction, and was able to answer and give and shed light on many important uh, questions of jurisdiction that arose in yesterday's session. I want to welcome you, sir, and thank you for attending, for taking some time off to attend today's session as well. With that, I would like to thank all of the participants for coming on to the second session as well, and thank Advocate Zakir Hussain for agreeing to be the resource person. And I would like to hand over to my colleague Shardul for introducing Advocate Zakir Hussain sir, and then starting off with the sessions. Thank you very much.
Thank you, Darshana, for the wonderful introductory remarks. And of course, as you mentioned, to the Assam State Legal Services Authority and Honorable Justice N. Kotiswar Singh for facilitating and making these sessions possible over the course of this week and the next week. We welcome you, Mr. Zakir Hussain, sir. We're really glad that you could come on board today. Giving a brief introduction of sir, Mr. Zakir Hussain is an advocate practicing in the Gauhati High Court and across multiple district courts and foreigner tribunals in Assam. Sir is extremely passionate about issues of citizenship determination and has over the years represented multiple persons in need of legal aid and assistance. He has also extensively guided them around issues of access to documentation. Sir is also aiding junior lawyers by sharing his experience at a personal level and through multiple training sessions that he has conducted over the course of the last many years. He's an active member of the Justice and Liberty Initiative, a trust that is actively working in human rights issues and fighting pro bono for the poor citizens before the High Court as well as before tribunals. We're extremely grateful to have you here, Zakir, and we thank you for deciding to join us today and readily agreeing to impart your expansive knowledge on drafting in foreigner tribunal cases and the specifics of how to go about such. We hope that everyone can make utmost use of Sir's teaching today. With that, before handing over to Zakir, I'd also like to remind everyone again to please follow the housekeeping rules and to keep yourself muted until you have a question and until we start the question and answer session. With that, I'd like to hand over to you, Zakir, for you to go ahead and start with the session. Thank you.
Assam State Legal Service Authority and His Lordship Justice N. Kotiswar Singh for his keen interest and support in this issue in actually conducting this program, and the pain and effort taken by Shardul, Rupali, and all the team of the Parichay group who has been working constantly with us and have been in discussion actually regarding the issues, foreigner issues, and how to protect the right of the foreigner case litigants, and what are the effective ways. And so actually we are trying to find out some some solutions in this regard or helpful ways which can in reality help us in protecting their rights effectively. So under their auspices, this program has been conducted, and I'm grateful to the Parichay Group and the Assam State Legal Service Authority for giving me an opportunity to share my experiences, which has been gathered in this field through practice before the tribunals as well as in the High Court for this last about 6-7 years constantly. And during this period, I have faced so many situations which can be termed as adverse situations. And in the adversity, I have learned some lessons, which actually I would like to share today. Because these spaces, this kind of case is a very different kind of cases here. Because unlike the civil procedure or the criminal procedure, here is no straightforward formula for fighting the cases before the foreigner tribunals. So herein, the foreigner tribunal has been empowered to make their own procedural rules, and taking advantage of that particular provision, the foreigner tribunals are dealing the matters as per their own choice. So the system or the procedure differs from district to district, differs from tribunal to tribunal, member to member, it varies. So actually we cannot go by one formula. First of all, we should know from the office or from the court itself or from the tribunal itself in which manner it has been proceeding with the cases. So for example, in some of the tribunals, they are actually allowing 10 days time or 15 days time to file a written statement or to file evidence or to argue the matter. But in some other cases, other tribunals, they are allowing 1 month time, 25 days time, 1 month time, 1.5 month time. So this difference in approach of the tribunal often pushes the proceeding to some awkward situation. So in my cases, I have dealt with about 70 cases, completed 70 cases of myself own, in which cases I have been able to succeed up to 90%. So from these cases, I have gathered some experience. And I think if I share my experiences with the present participants, it will be of some help. And first of all, let me clarify that I am not an expert. I'm not an expert, just a learner. And I shall try to share just my experiences. I am not going to teach anyone anything. Don't be under that impression. So the effective ways which I have found out during my journey for this last 5, 6, 7 years. So I think that will be helpful. So I have been here today. So my seniors and friends, here the proceeding starts with a simple notice. As Lordship Justice Kotiswar Singh has observed in the judgment of Hyder Ali, and in Hyder Ali's judgment, that is paragraph 27, last part, that thus, while the written statement as understood under the CPC is a defense put by the defendant with reference to and response to the specific averment and allegation made in the plaint in response to the plaint in the case of a proceeding before the tribunal. No such plaint or the charge is filed except for informing the proceeding through a mere notice or summons issued by the tribunal by making an allegation that the proceeding is not an Indian but a foreigner who came to India on a certain specific period of time. So the proceeding starts with only a notice. The notice says that you have been suspected to be a foreigner of a definite or a specific term, either of 1966 to 25th March 1971 or after 25th March 1971. So this notice on receipt of this notice, the notice says that you are to appear before the tribunal and answer this allegation. This is the only allegation. So that the allegation says that you have entered into Assam or India from specified territory after a specific date. In most of the cases, it is given that you have entered after the cut-off date of 25th March 1971. Besides this, there is nothing. So in a civil case, the case starts with filing a plaint and the case is defended by the defendant, or the suit is defended by the defendant by filing a reply to the specific averments, to the specific statements made by the plaintiff in the plaint. But herein, there is nothing. Herein only an allegation that I have entered or you have entered into India after 71. So under such circumstances, how a written statement can be filed? Where there is no plaint, how a written statement can be filed against such a vague allegation? So it is not a simple thing like CPC, or in a criminal procedure, the proceeding starts with the filing of charge sheet before the court, which includes all the materials collected against the accused person, including the witness, the statement, 161 statement, thereafter the seizure materials, etc., etc., and the opinion of the police after closure of the investigation. But unfortunately, in these cases, we get nothing. In Foreigners Tribunal case, FT cases, we are getting nothing, just a mere suspicion. And against this suspicion, what to be write? What to be written? So actually, initially we were in cloud. The lawyers, including myself, was also in a cloud, under some cloud, that what to be written. Then we perused the judgment in Sarvananda Sonal case, one case, Sarvananda Sonal one case of 2005. There the Honorable Supreme Court has stated, which has been also made a part of the judgment of Hyder Ali, at paragraph 41. Paragraph 41 of the Sarvananda Sonal case says that under the Foreigners Act, Section 9 imposes a burden upon the proceeding to prove that he is an Indian citizen. So to prove Indian citizenship, what he should do, he or she should do. So in Sarvananda Sonal versus Union of India 2005, 5 SCC, page 655, this is referred to in Hyder Ali's case also, in paragraph 41 of Hyder Ali case. It may be perused. In paragraph 41, it is written that there is a good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country in order to establish one's citizenship. Normally, he may require to give evidence of his date of birth, his place of birth, name of his parents, their place of birth and citizenship, sometimes the place of birth of his grandparents may also be relevant, like under section 6A1D of the Citizenship Act. All these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given evidence on this point, the state authorities can verify the facts and can then lead evidence in rebuttal if necessary. So I'm coming to the latter part actually regarding the verification, which is the actually observation of the Honorable Court. So initial burden. Section 9 imposes the burden, initial burden, the burden upon the proceedee to prove that he is an Indian citizen. So in a written statement, we have to place our life history, the life history of the proceedee. And there should be an endeavor to connect the proceedee with the person concerned who was an ordinary resident of Assam or India since prior to 1966. So the Hyderabad case also says that the fact in issue, what is the fact in issue? The fact in issue is that the proceedee should try or proceedee should establish his lineage with the person who was an ordinary citizen, ordinary resident of India or Assam since prior to 1966. And to prove this fact in issue, we will have to file a written statement. Now, as the word written statement is used, so we should be guided by the CPC. Now, CPC order 8, rule 1 simply says that defendant shall within 30 days have to file the written statement. But herein, in Foreigners Tribunal, there is no such binding or no such time period is also given. Because Foreigner Tribunal says, Foreigner Tribunal Order 1964 says that the proceeding must be completed within a period of 60 days. So this time period is not relevant in the foreigner cases. We will have to file it within reasonable time. So next thing is that the written statement have to be verified and all the pleadings are to be supported by an affidavit. In some cases, while dealing in the High Court, while preparing some cases, preparing some writ petition, we have found that some of the lawyers, some of our brothers do not file the required affidavit with the written statement. I think this should be done because the CPC says that rule order 6, rule 15 of CPC says that verification is required, and in the year 1999 an amendment was brought which says that the person verifying the pleadings shall also file an affidavit in support of his pleadings, and pleadings includes plaint as well as written statement. So the verification as well as the affidavit is to be filed while filing the written statement. And we often see some of our friends pasting or paying court fee, affixing court fee with the written statement. But as per the Court Fee Act 1870, for written statement, For written statement, court fee is not required. Court fee is not required. So only the court fee is required for the affidavit. So these are the formal things for filing a written statement. Now, what should a written statement contain? Coming to the main aspect of today's session, that how a written statement is to be prepared. So prior to that, I would like to say that during my practice as a foreigner tribunal lawyer, I have found that most of the persons are from the very backward areas, illiterate, and they are financially very weak persons, like rickshaw puller, maids, daily wage earners, and in 90% of cases they are illiterate. So these persons have no concept about time, no concept about day, year, etc. So this is a very problematic indeed. So our first duty, I think, our first duty prior to preparation of the written statement is to have some proper instruction. And if we succeed in taking proper instruction, bringing out the proper instruction from the concerned litigant or the opposite party, then our half work is done. And for this, we need to interact with not only the opposite party, but also with his or her relatives, his or her parents, his or her other family members. Then only the truth can come out. Because this person against whom the cases are generally found referred are not from the pre-71 stream. They are not born in the pre-71 era. They are born after 71. So there are to establish linkage with the person who are or were ordinary citizen of India since prior to 1971. So these people who are born in 1974, 75, 80, or after that cannot say anything about their predecessors except the name and addresses. So for this, in most of my cases, I have conducted numbers of sessions, because one person says something, thereafter his or her relative comes and says some another thing. So for instruction is a painting very laborious thing. Proper instruction should be taken, and this should be noted down, and we should not do any hurry, relying on the sole statement of the opposite party, and file the written statement immediately. Because if after filing of the written statement some facts which is new that can be introduced by way of additional written statement, but if some contradictory thing comes, then it will cause heavy damage. So we instruct generally after the first session to bring his or her relatives, some elderly person including parents, to us for further clarifications. And then comes the scrutiny of documents. What documents they have at their disposal with them at that time, at the relevant time. It may be certified copy, it may be uncertified copy, it may be a receipt, it may be a old sale deed, it may be any document, certified, uncertified, it doesn't matter. So we should take it, then we should scrutinize it. We should try to find out the discrepancies. Suppose in the year 1966 document, his father's name is written as some Ali, Karim Ali, but in 71 it is Karimuddin. Then in 85, his name is Karimullah or Farimullah. So these discrepancies is to be noted. Discrepancy of the ages is also to be noted. And thereafter, we should prepare a draft history, the life history. The life of the proceeding is to be noted down. So then the proceeding is to be advised to collect the relevant documents, certified copies of voter list, certified copies of land records, that is Jamabandi, or the copy of registered sale deed if the original is not in good condition, then the certified copy from the concerned sub-registrar office. And while advising, I have seen many of our friends are taking or advising them to collect a copy with only the name of the concerned proceeding. This is fatal. We should try to collect, or the proceeding should be advised to collect the name of all the persons against a single house number. If there are 4, 5, or 3 persons there, all the names should be copies in respect of all these persons should be taken together. But in some of the cases, unfortunately, we have seen that this is not done. So the tribunal members, in their opinion, often writes that the voter list does not contain the name of his father or mother or any other relative. So he has failed to establish linkage with the projected father, mother like this. So we should try to avoid this practice and try to advise, and we should advise the litigants or the proceeding to collect document in this manner. And if the proceeding inherited any land from his or her predecessor, father or mother or grandfather, that should be tried to, that document is to be collected from the concerned circle office. And the proceeding should be advised to pay the land revenue in respect of the land. That is a very good document. And in case of school certificate, we have found that some school certificates are given to us. And we readily put this document in our written statement as an example. But afterwards, when we ask them whether the concerned headmaster will come to depose or the concerned staff will come to depose in support of this document, then they say that the school is no more there. And the school says no record is there, etc., etc. So prior to annexing this document, we should advise them to have a consultation with the concerned school staff or the headmaster, responsible person, to verify that whether you have any record pertaining to this document which has been given to us, given to my father or given to my mother or given to my sister, whether you have any record with you. So after verification of this aspect only, this document is safe to be placed in record. And next, the Panchayat document also. The Panchayat document can be made a part of the record, provided the Panchayat office has some record, original record of it. Because in Rubjan Begum's case, the Honorable Supreme Court has said that proof of document is also means the proof of the contents of the document. We have to examine the issuing authority and also have to authenticate the contents. Then only this document can come to help us. So these documents, while preparing a written statement, hello. So first of all, in a written statement, while drafting a written statement, hello. Hello. Is it okay?
Sir, we can listen
Yes,
to
sir,
you.
we can hear you.
Oh, yes, I'll continue. So prior to drafting a written statement, our prime duty, as our Sir Sikdar sir told yesterday, that we should first verify or go through or scrutinize the reference itself. On earlier occasion, the tribunal did not issue the references to us, but now I have seen that most of the tribunals are allowing to peruse the reference and also issuing these certified copies of the reference. So in some cases, I have found that while I was trying to prepare the written statement, and in my mind it came that I should go through the reference, and I went through the reference, and there I found that the referral authority has written that the concerned person seems to be an Indian, or there is no remark as regards whether he is Indian or foreigner, or from which stream. In this regard, the reference is totally blank, or the reference says that he seems to be Indian as per the NBO report, the NB report, native village report, etc. So at this juncture, we should not file any written statement. Rather, we should try to go for dropping of the proceeding. And for dropping of the proceeding, the Honorable High Court is very much clear in the case of Tuazuddin versus State of Assam or Union of India. In that particular case, the tribunal insisted for continuation of the proceeding and finally declared the proceeding a foreigner. Whereas the reference says that this person is an Indian. The reference says this person seems to be Indian, and the SP forwarded the reference to the concerned tribunal for its opinion, and the tribunal, without going through the reference properly, in a very mechanical manner, issued a notice stating that you are suspected to be a foreigner and compelled, yes, this is the judgment, and compelled the proceeding to contest the case and finally declared him to be a foreigner, this Tuazuddin. Finally, the proceeding approached this Honorable Gauhati High Court, or Honorable Gauhati High Court, saying that the reference says that I am not a foreigner, but the tribunal declared me a foreigner. At this, the Honorable High Court, our Honorable High Court, clearly says that the tribunal, at paragraph towards the end, that is Tuazuddin case, I think. This is been shared. Is this Tuazuddin case?
Yes, sir.
Yes. Herein, just page 3, please. Yes, the last paragraph. On the face of the materials on record, yes, this is evidently the tribunal had traversed beyond the term of reference, tried to say a foreigner tribunal assumes jurisdiction only after a reference is made. The jurisdiction is to render an opinion within the terms of the reference and not beyond. It is well settled that the Foreigners Tribunal requests requires to prima facie satisfy itself with with regard to the existence of the main ground before issuing notice. While going through the materials collected during the investigation, if a tribunal finds that the reference made was incorrect or faulty or did not require a proceeding to be initiated on the basis of the report of the referral authority, the tribunal should return back the reference to the referral authority, yes, that is Superintendent of Police, to reconsider whether a fresh reference is required to be made. So with this observation, the order was set aside. The order of the tribunal was interfered. So if we try for dropping of such proceeding at the initial stage, then the proceeding would get good relief, early relief. So in 2 or 3 of my cases, I have tried it, and it has been effective, and they got early relief, and the references were dropped and sent back to the concerned SP border for reconsideration if so advised. So while filing such petition for dropping, if the proceeding, if the reference says that the person seems to be Indian, or the reference is not clear as to from which stream this person belongs, or the allegations are vague. So under such circumstances, we can go for dropping. And in this regard, the Honorable High Court has earlier also stated in a case of Santosh Das, that was uh, 2008. Santosh Das case. Therein also the Honorable Justice Ujjwal Bia has said that a tribunal cannot go beyond the reference. So these 2 cases are helpful. This is Santosh Das case. These 2 cases may be referred while preferring a petition before any tribunal for dropping of the proceeding. So if the proceeding is not dropped and the reference is clear, reference has stated clearly, rightly or wrongly, that this person is suspected to be a foreigner of such and such stream, then we will have to file a written statement. And prior to filing the written statement, we should also try to see whether the name of the proceeding, his father's name or his or her husband's name, or the address has been properly written or not. So if there is some similarity, but the name is not exactly the same, father's name is same, but his or her name is written with some difference in the title, etc., there should be tried to be clarified in the initial paragraphs. And it is prudent to start the written statement by giving the details of the correct address, name and address of the proceeding in the cause title itself. Like the case number is written above, thereafter Union of India or State of Assam versus such and such, the OP. Then we should write his father's name or husband's name, address, etc., etc. In case of female proceeding, we should give the name of her father as well as her husband and her present address. Though the reference may record some other address, the correct address should be given. Thereafter, we should start with the preliminary objections. The general objection which we put generally in a civil case, like the case is not maintainable against me, the case is bad for non-investigation, etc., etc. And we should clearly write about the, if no investigation is made, if we come to know from the proceeding that at no point of time any police officer or any government official visited her place or made any spot verification, etc., then we can vehemently deny or specifically state that at no point of time the police visited my place in connection with any citizenship issue, and the entire exercise has been carried out behind my back. That is against the principle of fair investigation as stated or as mandated by the honorable courts in Muslim Mandal case and other cases. So that is in the violation of the principle laid down under the Muslim Mandal case. And while denying as a rule of the pleading, rule of CPC, so the denial should be specific and evasive. Admission should be clear, and denial also should be clear and evasive. We should clearly deny if no investigation is made. We should clearly deny that no investigation was made. And if the notice is vague and notice does not specify any place from where I have come, the date or period when I have come, etc., then we should clearly mention about these things. That non-mentioning of this thing states or shows that there was in reality no investigation. So thereafter, after the preliminary objections or preliminary submissions regarding the non-maintainability of the case against the proceeding, we should proceed with laying down our own case. In terms of the Sarbananda Sonowal verdict, we should start chronologically from our predecessor. That is, he may be our grandfather, great-grandfather, father, mother, like this, from the pre-1966 period. We should try to draw a story of the proceeding. So while writing about the story, while laying down the story, first we will have to place a brief, concise story that my grandfather name was such and such, my father's name was such and such, my father's such and such, siblings, and thereafter the name of my mother is this, and from these parents, 4 or 5 or 6 children were born. I was born in the year so and so at such and such place. So this is the outline of the story. Then thereafter, this story will have to be substantiated by the annexers. That is the documents which I am relying in support of my citizenship. So the certified copies of voter list, if available, we can place it with our written statement. If not available, then leave has to be kept that I am leaving that I crave the leave of this honorable court to place the certified copy at the time of evidence or through additional written statement. So the leave to be taken. Then actually there is no hard and fast rule that with the written statement we have to file all the originals or the certified copies, because certified copies and originals are to be exhibited during the evidence only. But if we wait for long time for the certified copies to come and then file written statement, then the court may take some adverse step against us. So if we have a written statement, if we have the certified copies with us readily, then you can place it as an exam. If not, then the uncertified copies or the relevant page of the voter list containing the name of the predecessors or the proceeding can be annexed. So this is not fatal here, but we should keep in mind that we should place the original documents or the certified copies during the evidence. So while placing the documents, the chronological order should be, we should try to trace out the document of pre-19, and we should try, or we should
Not audible.
Yes, we're just following up with sir to check. I think maybe he may have lost connection. Sorry, everyone. I think Zakir has lost connection. We are just calling him up to find out if he can rejoin quickly.
Sir has had a slight connection issue. He lost out on networks. He'll just be rejoining in a moment.
Sir, you're on mute.
hello.
Yes,
Hello.
sir. Yes, sir. We can
Yes,
hear
sir,
you.
you are audible.
Oh yes, there was some actually network issue. So I'm sorry that there is some interruption came in our way. So I'm coming back to the issue of the written statement. So written statement, as His Lordship Mr. Kotiswar Singh has stated in the case of Hyder Ali. Hyder Ali is a very good piece of judgment where you can get everything regarding the Foreigners Tribunal cases. Herein, actually, Lordship has stated that there is nothing like formal written statement. Actually, what we should try to do, we should try to connect us with our predecessor through some valid documentary evidence, or oral evidence. So the written statement should include or reflect my life, the life of the proceeding, who is her predecessor, from whom she is claiming the linkage, because most of the proceedings are of post 1971. They are born here, but their problem is that they cannot establish linkage with their predecessor or the pre-71 person. The breaking of linkage is the issue here. These persons, as alleged in the notice, that you have entered through some secret route without that is a valid document or valid passport, these are nothing. Because actually, if I go by their age of the proceeding, we will find that all of them are born post 1971. So in our written statement, our endeavor, the style of every lawyer is different. My style is different, others' style are different. But our aim should be to place before the tribunal a clear picture, a family tree from where the tribunal can easily find out the linkage of the concerned proceeding with the person of 1966 or 71. So how we place it, that is the issue here. That is the question. So while placing the document, we should try to avoid conflicting documents. We should place clear and the documents, clear documents, which do not create any doubt. So number of document is not here the material, the quality of document. If I place 1966, thereafter 1971, if there is some gap, I cannot find out 1977, 75 or 85, I should make a statement that I have tried, I have applied before the concerned authority for this document, but the authority has not issued it. For this, we may find a copy of petition which is with us with the proceeding that I applied for, but that has not been issued till date. So that is also sufficient. Thereafter, you can place 1989, 1993, 1997, etc., so on and so forth. So this gap, but this gap to be explained. In some cases, we find that after 1966, the proceeding annexes document of 1997. There is a huge gap. So this unexplained gap is also fatal because continuous stay is a mandate. Continuous stay is to be proved to be a citizen of India. So if a person was an Indian citizen in 1966, he may go back to his country of origin prior to 1971. Then he may come again in 1990. The prosecution side can think all about this. They can cook up their story in this manner. But it is our duty to show that I or my predecessors have been staying here continuously since long. And that is to be proved by oral or documentary evidence. But mainly the tribunal relies on documentary evidence. So if I have no document, then at least I will have to make a statement. I cannot leave blank. This area cannot be left blank. So thereafter, this shifting, this is very interesting and very crucial because the High Court often makes query regarding this aspect, that your father's name in 1966 is in such and such place, A village, but his name is changed and his name now you are showing in B village. Here was Karimullah in 1966 in A village. In B village, that is Kasimullah. So how these two persons can be same? We are making a statement that these two persons are same in one person with single identity. But why should I believe? Because the burden under section 9 is upon me, upon the proceeding to prove. But if this shifting from A place to B place is not pleaded with some documentary evidence, then this may go against us, against the proceeding. So this shifting is to be clearly pleaded. The shifting aspect is to be pleaded clearly. Then the discrepancy in name and age. So for this, some of the friends, some of our lawyer friends are giving or filing affidavit, self-declared affidavit that that there is some discrepancy in my name in this place, in this place, in this place. So this affidavit is of no use. This piece of documents has no evidentiary value at all. But the best way is to do one thing. You take some paragraph, you make some paragraph, specific statement regarding that in such and such place, my name is written in this manner, in such and such place, my name is written in such manner, and I declare that I am the same and one person with these names. Likewise, the discrepancy in the name of father, discrepancy in the name of mother can also be pleaded here in the written statement itself. And these very things you can plead in your evidence in chief also. So these will be of some help. But filing extra affidavit is of no use. And likewise, the age factor also. The ages, if there is huge difference, then you should make specific amendment that as per 1966 or 1970 voter list, my father's name is this, and his age is this in 1966. But as per 1966, his age in the year 1985 should have been this, but due to some mistake of the concerned electoral staff, the age has been written on higher side or lower side, etc. And the correct age is this. So far my information is concerned. So in this manner, we can try to clarify the discrepancies regarding age, name, etc. And we should place or write clearly about these siblings, how many siblings we are, how many are alive, how many have died. So this is enough. But only writing about myself is not enough, because if I introduce some witness during the evidence saying that he is my brother, if there is nothing regarding him in the written statement, then this will cause some problem to the proceeding, because the prosecution will go by surprise. So what our endeavor should be to place my life on papers. Nothing more than this. To place my life on the papers, because the cases I have dealt in, most of the cases, about 99% percentage of cases, the people are of Indian origin. So the decision has gone in their favor. But the problem is that the people, these proceedings, these persons who have been served with the notice, due to their illiteracy and ignorance, cannot instruct their counsel in a very appropriate manner, which actually is leading to the adverse orders. And unfortunately, some of our lawyers are also committing some mistake. And I am ashamed here to say that some of our lawyers even doesn't know the difference between annexure and exhibit. So what document to be exhibited and what document to be marked as annexure, if this difference, we are not aware about the difference, then how can we defend the precious right of a citizen? So I think for this, they need some special training to be given by some good civil lawyers. Our senior lawyers who are dealing with the civil cases on a regular basis, they're expert in civil law. So that is actually very much important. Due to most of the cases in the foreigner tribunals I have seen have been decided adversely due to the improper or poor doctrine, poor placement of the case of the proceeding. So if we be do it very sincerely by placing the relevant facts pertaining to the proceeding as required under law, as directed, or as laid down in the cases of Sarvananda Sunwal, Muslim model, etc. That what should we place? And the Hyder Ali is a very good piece of judgment. And so, in foreigner cases, there is nothing like the written statement. It is not very technical. It is not very much technical, like the CPC cases, like the cases under the civil procedure. Herein, we should try to just make out a case of the proceeding, the life of the proceeding on papers. And in the next stage, we should try to make the proceeding familiar with the pleadings that I have stated so and so. You have stated me these things, I have placed these things in papers, and you should support these things before the tribunal. And for that, prior to the evidence, we need to give some practical training, 2 or 3 sessions with them, including their parents, if available. If not available, their elder brothers, their paternal uncle or aunts. Because the oral evidence, Hyder Ali case says that oral evidence has tremendous value. So if the official witnesses do not come, or I cannot place any document like the linkage certificate of Panchayat or other land document, etc. Only I have voter list in my disposal. Then the evidence of my parents, of my relatives, are of utmost importance, as Section 50 says. But for these, we should bring the names of the relatives into the record, and thereafter, after filing of the written statement in the evidence stage, prior to evidence, we should train up them so that they can face the cross-examination or the examination under Section 165 of the Evidence Act. So, now another thing is there, that while preparing our written statement, we should make clear statement regarding the fact that there is no D, or there is no case under Foreigners Act pending against the proceeding or her parents or her predecessors before any other tribunal, and that they have been, or he or she has been casting vote regularly from such and such place without any break, etc. These things should be there to lead the court to the presumption that this person is an Indian citizen, because none of the family member has been proceeded under this act till date. So these things should be a part of the written statement, I think. And some documents like PAN card may be avoided, because the PAN card bears the date, and during cross-examination, sometimes we find that this illiterate proceeding often fail to state about the date, which contradicts her own statement. So if she can say, or he can say, the year of birth may be mentioned in the written statement. But this document, PAN card, is of no use, because you cannot prove this document by calling the PAN card authority from Bombay or some other place. So the voter ID may be given, but the PAN card may be avoided, because they are not tax paying, so they cannot stand the cross-examination during the cross-examination regarding this document. And the ration card, etc., is of no value. But the number of document you place, it will contradict the other document. So if maximum number of documents are annexed, there is a chance that the document will contradict each other in some point, and it will create trouble or cause problem to the proceeding. And another problem I would like to bring to the notice of the State Legal Service Authority we are facing presently, with a hope, with some anticipation that the State Legal Service Authority can uh, assist us to some extent in this matter, that is regarding the non-issuance of certified copies within time. In most of the districts, the certified copies are not issued for about 2, 3, 4 months, even for 6 months. I have seen in many of my cases that the authority are not issuing the required certified copies of the voter list, which are very much required for contesting a case before the Foreigners Tribunal. That is also creating a great trouble. And as the date, as the time stipulation, as the stipulated time is there, that is 60 days, that taking advantage of that provision, the proceedings are not allowed too much time, and the cases are often declared expired. And actually, in recently, one of my cases, Osman Ali or Osman Ghani, that happened. Unfortunately, the Honorable High Court has given him bail, and the case has been remanded actually for first disposal. And actually, in that case, the certified copies were not issued within time despite application. So I think the State Legal Service Authority and also His Lordship, our Justice Honorable Justice and Kotiswar Singh will notice this problem and try to give some effective order or instruction so that the litigants get some relief. And now I would like to say that most of the participants here, being lawyers, are very actually well versed in preparation of petition as well as the written statement. And so whatever I have stated, all these things are known to them. But my appeal to them is that the proper scrutiny. I am here, actually I am not an expert, as I have told you already, but I am a fighter. I am not expert, I am a fighter for these people, these litigants, these citizens who have been proceeded under the Foreigners Act, and I have personally seen their life, interacted with them, and some intimacy with them, and I'm trying my best to do something for them personally, and also from my trust, Justice and Liberty Initiative, which is doing a great work by pro bono service, giving pro bono service in High Court as well as in the lower, the tribunals and district courts, etc. So I'm fortunate that the Parichay group has given me the opportunity to share my this little experience with the participants, and I do not know how much I have been able to share with you, but these things were actually whatever I have stated here. These are my own experience, and using these techniques, using this procedure, I have been able to win lots of cases for the needy people. So herein, I would like to conclude my opening discussion, and I shall try to clarify if any question or query is coming up. I shall try my best.
Thank you so much, Zakir, for that detailed session and for taking us through the intricacies of drafting before the tribunal and guiding everyone as to how we should proceed when finer issues such as discrepancies, lack of documents come up, and also points of differentiation coming up in the use of multiple documents. The way you laid it down was extremely helpful to us, and we would be proceeding to questions now so people can clarify the doubts that they've been having. We have Mr. Borhan Ali Ahmad who's raised his hand. Sir, if you would like to unmute and ask your question to Zakir. Mr. Borhan Ali Ahmad. So you can proceed to ask your question.
Yes, Burhan. Yes, Mr. Burhan.
So maybe till then we can take up the question in the chat box and then come to Mr. Borhan Ali Ahmad. So Bodius Zaman sir has asked a question in the chat box. He's asking, why do the foreigner tribunals have the choice to entertain their own cases? And shouldn't it be under some procedure and written down under the law?
Hello.
I'll just repeat that question. Why do the foreign order? Sorry, sir.
Yes,
I was just repeating the question for everyone. Why do foreigner tribunals have their own choice to entertain their cases, and should not there be some procedure under which it is written down? Was the question asked by Mr. Bodius Zaman. Over to you, Zakir.
Mr. Zaman, regarding your question, the foreigner tribunal has been given with the liberty under the foreigner tribunal order that they can be guided by their own procedure. As I have told you, told the House already, that taking advantage of this procedure, of this specific provision, the foreigner tribunal has been doing all these things. And actually, as I have told you, this procedure is different from court to court, from tribunal to tribunal, from district to district. They are taking recourse to this provision of the Foreigners Tribunal order, that 3C3, Foreigners Tribunal order 3C3. If you have the Foreigners Tribunal order, can see 3C3. Subject to the provisions of this order, the Foreigners Tribunal shall have the power to regulate its own procedure for disposal of the case expeditiously in a time-bound manner. So this 3C3, they are using as a weapon, as their tool. So whenever we question something, that why you are doing this, why this tribunal is dealing such matter in this manner, and this is different to other tribunals, then they clearly say that we have been empowered to proceed with our own procedure, which is effective for disposal of the case in a speedy manner. So we are not bound by CPC or CRPC. And the Honorable High Court in a number of judgments has also stated that the rule of civil procedure or criminal procedure are not directly applicable in the Foreigners Tribunal cases or under Foreigner Tribunals order. They have own order, that is Foreigner Tribunal order 1964. So under these circumstances, that we are also not bound by the CPC, and we are also not bound to exactly follow the rules of CPC while filing a written statement. So we are filing a reply, just a reply. It may not be in the pure form as stated in the in order 8, rule 1, 2, 3, 4 like this. We should place the life in a clear and unequivocal term of the process. Yes, Abdul.
Thank you. Thank you for
Hello.
that response. Hello.
Yes, Abdul. Yes,
Yes,
Abdul.
sir. Thank you. Thank you for that response, sir. We're just reaching out to Advocate Boran Ali Ahmed for the question, and then we can take
Yes.
that question. Advocate Boran Ali Ahmed, can you hear me? Advocate Asghar Ali also has a question. If you'd like to unmute, sir, and ask a question.
Hello.
Yes, sir, we can hear you.
Good evening to everyone. I'm MD Asghar Ali from Chirang district, sir.
Yes.
Zakir Hussain sir has very nicely, elaborately discussed the issue regarding the filing of WS. My question is, sir, in Chirang district, while I filed WS, the Foreigner Tribunal member raise a issue that public document voter certified copy of voter list issued by the public authority. I tried to convince the Foreigner Tribunal that since it is issued by the public authority in the capacity of public officer, so should I call the issuing authority, or should it be accepted by the tribunal? Then the Foreigner Tribunal replied that you should call the issuing authority.
Yes. Yes, Asghar.
So, yes, sir. So public authority, when the document is a public document, whether it needs to be proved by calling the issuing authority?
No.
Yes, sir.
Yes, Asghar.
Yes, sir.
Regarding
Yes, sir.
your question, yes, I'm trying to answer your question. The actually certified copies of a voter list is a public document, and it actually is not required to be proved by calling the issuing authority or the maker of the document. That is the mandate of the Evidence Act. But in a case, in earlier case, the Honorable Gauhati High Court, Justice Ujjwal Bhuiya's judgment was there. Actually, I kept all these things for the next session. However, I'm trying to answer you that the Honorable High Court, in a judgment, I will give you the judgment later on, stated,
Okay.
Justice Ujjwal Bhuiya, Justice Ujjwal Bhuiya's judgment was there. In that particular judgment, Justice Ujjwal Bhuiya said that though the public document is not required to be proved, there is some suspicious document or some corrupted documents are coming forth during the NRC, and actually in front of the tribunal also there are some documents which are coming, which are corrupted document or tampered documents are coming. So it is not safe to rely on this document, and the Honorable High Court laid down that and actually held that these documents are required to be proved. And under that order, the foreigner tribunals were insisting for proving the documents. In some of my cases, I have also proved the document by calling the issuing authority under pressure of the tribunal and considering the welfare of the proceeding, as I had no way out. But subsequently, fortunately, one judgment came there, that is Mujibur Mia versus Union of India. Mujibur Mia versus Union of India writ petition decided in the year 2018, I think. In that judgment, the Honorable High Court has clearly stated that voter list, certified copies of voter list, as well as the Jamabundi, etc., which have been issued by public authority, are not required to be proved by calling the issuing authority. You can have this judgment, and the Rupali or Shardul can share this judgment. Mujibur Mia's judgment is there. So, if the tribunal is insisting on such things, you can file a petition annexing this judgment and saying that these documents are not required to be proved. You may not go for proving this document. Hello?
Yes, sir.
Asgar?
Yes, sir. I am hearing.
Yeah. With the written statement, you can file the uncertified copy or the certified copy. It is your duty to produce the certified copies only as exhibit with the written evidence. And during evidence, if you do not prove, then your case will be adversely affected if the tribunal is not accepting that document without being proved. But these things you should place during the argument. In argument, you should place the judgment of Mujibur Mia, and if possible, you file a written argument with this judgment. And there are other judgments also of the Supreme Court. If you get in touch with us, we can provide these judgments also of the Honorable Supreme Court. Then with this, you file your written argument. If your case is adversely affected, you will get relief in the Honorable High Court. The member cannot insist for something which is not the mandate of the law. Okay, are you clear? The Mujibur Mia's judgment you cannot do.
Okay,
Yes,
thank you, sir.
Mia. Welcome.
Thank you.
Any more questions, Abdul?
So yeah, if anyone here has any questions, you could raise your hand or directly type them in the chat box. So we have Advocate Tariq Ansari who has a question. So you can unmute yourself and go ahead.
Yes, Tariq Bhai was yesterday also was there.
Hello, everybody. Actually, I'm not an advocate,
Yes, Tariq Bhai.
but I have attended so many seminars like this.
Yes, yesterday you were there.
Yes.
Yes,
Yesterday
I got. Yes, I was also participating yesterday.
Okay, yes.
Yes, please.
Sir, in one program, Khaddam Bhai said that there cannot be any cyclostyling of written statement, and we believe that yes, really there cannot be any cyclostyling of written statements. But my question is that there should be some questionnaire, some psychostyled questionnaire, which a junior lawyer will use as a help for the senior
Yes,
lawyer.
yes, very good question.
Yes.
Yes,
I think
yes, very good question.
prepare a questionnaire. And you said that written statement is all about genesis and biography of the proceeding. So there should be a bigger questionnaire so that everything is included. And after answers are prepared, so that our senior advocate can omit the irrelevant things. And this is my request to.
Yes, sir. Very good suggestion.
Yes, and I have some. I will ask you later. Thank you.
Yes, Tariq Bhai. Very good question indeed. Very good suggestion. Actually, this is, and actually regarding this suggestion, I would like to share that I am actually taking instruction for the written statement in some set formula. And as Tariq Bhai has said, that we should prepare some questionnaire. This is a very good suggestion. It can be prepared because there is a technique, there is a very different technique for taking the instruction or obtaining the instruction from these people who are coming from very poor background, from actually very illiterate background, and they have no concept about time and anything. If we say when you were born, they cannot say. If you say what is your age, they will say 40. If you say no, your age is 50, they will say yes sir, my age is 50. So for extracting the relevant information from this person, from this class of people, we should prepare a questionnaire after having some discussion with some lawyers, and I can also give some questionnaire. Those questionnaire can be compiled and maybe circulated to the junior lawyers after being scrutinized by our seniors that these are the valid questions. So this can help in extracting the relevant information which are to be placed in a written statement. Very good suggestion by Ansari bhai.
মোৰ আৰু এটা প্ৰশ্ন আছিলে I have one more request. That is, see, we want to help the lawyers, and here when a judgment is mentioned, there should be a paragraph number. And see, generally what happens, our Tista Sitalbad also shared many resources, but that is not the thing. If you are giving us encyclopedia, that is not very much helpful. If you give, actually you have to show also the relevant paragraphs also, which are relevant. And see, very, very long judgments are very much troublesome. So I think such resource should be prepared, such study material should be prepared, where specific paragraph numbers will be there.
Yes.
This is also my request to prepare such.
Ansari bhai. Yes. Ansari bhai, actually the relevant paragraphs in the Hyder Ali case, I have stated 41 of the Hyder Ali case, and some other paragraphs are actually there in Mujibur Mia paragraph 4, etc. So I asked them to share in the screen. So that is also a very good suggestion, that while sharing the case laws, we should specify the paragraphs. I have prepared that one also and shared with the Rupali Samuel, and Rupali will share it in the your mail or the mail of the concerned participants. I think I have given the particular paragraphs number also there.
Yes, sir.
Thank you.
So, yes.
Thank you, Zakir. We have, with the assistance of various advocates, including Advocate Zakir Hussain, attempted to compile a questionnaire of this sort, as Mr. Ansari has offered. So I can show I can share the screen and show the format. We are, of course, in the process of updating this based on the valuable suggestions that have come in this set of trainings. So we have tried to make it in a questionnaire format, as was suggested, with yes and no questions, and the kind of steps that can be taken, and the kind of suggestions that have come today that Advocate Zakir Hussain has shared with us earlier. For example, confirming the inquiry report, and as well as sharing the specific paragraphs of the important paragraphs of the case. So in a very concise manner, we are trying to place it all together in a useful format for everyone who's practicing. So we are very happy to continue updating this and preparing a very thorough handbook and set of materials. And as was mentioned yesterday by the learned member secretary of the Assam State Legal Services Authority, they are very supportive, and they will publish these materials, and they will also circulate it amongst the DLSAs. So we really welcome your valuable suggestions for how to put the material together in a way that is very helpful to everyone practicing. And thank you for sharing that suggestion. If there are any more suggestions for how to produce the materials and how to make it convenient, we can also incorporate that. We'll also be sharing the PDF copies of all the case laws with the highlighted paragraphs, so that all the advocates can easily take out the paragraph and place it before the tribunal. And we want to share the full copy as well, so that it will be convenient for advocates to print the copies if they need to be handed over in court as well. So if there's any suggestion about what will be useful for lawyers who are in practice, please share your suggestion, and we will also prepare the materials accordingly. Thank you so much.
Thank you so much, Rupali, for sharing that. And yes, please, I mean, if you have suggestions or ideas in mind regarding this, please feel free to write to us. We'll be sharing our email addresses and names as well at the end of the session. We have, Zakir, we have two more questions in the chat. I can just read them out. Advocate Divyanshu Saxena has asked a question asking whether if you can please elaborate on the difference between the terms prescribed and specified as used in the Section 2 of the Foreigners Act 1946. Advocate Divyanshu wanted to know more about the relevant fact and issue and the procedure that is required to be proved by the litigant as per the provisions of Section 3, subsection E of the Foreigners Act. I'm just going to repost the question on the chat so everyone can see it.
Section 2. Yes, Mr. Sadul. Regarding the difference prescribed, Section 2. Hello?
Yes. Yes, sir.
Mm-hmm.
Regarding the difference between the terms prescribed and specified as used under Section 2 of the Foreigners Act.
Section 2 of the Foreigners Act. Let me go.
Advocate Divyanshu Saxena, if you would like to unmute and also state out your question or any specific parts of your question, please feel free to do so.
Section 2. Prescribe me.
Yes, you're audible.
Yes, sir. So, like, my question regarding the Section 2 was more in reference to how.
Section 2 of the Foreigners Act.
Yes, sir. Section 2 of the Foreigners Act was in relation to how it can be a way this legislation is like giving levels to the delegation of central government and state government powers. And like if we can, through the interpretation of these two terms, can like spot that kind of a intended delegation of powers to the administrative bodies. Thank you so much, sir.
Question to actually foreign sector. So here in the Section 2 definition clause, actually definition. In this act, the foreigner means a person who is not a citizen of India. B, prescribed. I think this is the question. Is not it? Prescribed means prescribed by orders made under this act. Specified means specified by the direction of a prescribed authority. Isn't it?
Yes, sir. So like here this difference has been explained, but how it has been like actually applied in the Section 3 clause E and like the 6, 7, 8 sub clauses that I have mentioned like in the question as well. So there they're trying to ascribe certain criminality to the actions of the foreigners, but I wanted to know what will be the procedure to prove such facts or such adverse facts against them.
Here, see, this act actually was of 1946. This is a colonial act, and this act, as the our senior Sikdar sir has told yesterday, that this act is not at all relevant in the present context. However, all these things here written in this act of 1946. First, going to the prescribed means prescribed by order made under this act, and this for implementation of this act, there are some particular orders. That is procedural law. So procedure is there in the Foreigners Tribunal Order 1964. So prescribed means prescribed by the orders made under this act. So while dealing with the cases of Foreigners Tribunal, the prescribed means prescribed by order made under this act, and the rule is prescribed here for dealing with these cases. The rule under which this act is to be implemented, the act is to be carried out, is the order of 1964, and specified it comes in terms of some area which was specified by the prescribed authority. Here the delegation of power is to central or to the state, whatever the actually it may be. So in the actually foreigner tribunal cases, the specified territory is used, specified, that is used for Bangladesh or the East Pakistan. So these two terms, these are actually defining terms, and we deal mainly with the section 9 regarding the burden. And the other part, these were actually used during the colonial period and not in used now. They are not taking recourse to these provisions actually in the tribunal. The tribunal is going by section 9 and wholly following the order 1964.
Thank you so much,
And
sir.
these all relates to the person who were like the Australians, Japanese, etc., etc., and not relate to the present context, this person of Assam or the Indian, the person who are of Indian origin, but are alleged to have entered into India or Assam from the specified territory. The specified territory here is very specific, that is Bangladesh or East Pakistan. And prescribe here means the rule, actually the Foreigners Tribunal order. Mr. Abdul.
Thank you so much for answering that, sir. Thank you, Devanshu, for your question. So we have one more question from Advocate Sadullah Haq. The question revolves around cross-examination and evidence in chief by the member of the Foreigner Tribunal. Advocate Sadullah, would you like to unmute yourself and ask the question, or should I read it out?
Good evening, sir.
Good evening.
Okay. Sir, I am from Barpeta. My name is Sadullah Haq.
Yes.
And in live session, I have problem to speak fluently English. That is why I would like to change my language into Assamese. Is there any problem, sir?
No problem. No problem. You can carry on in Assamese also. I have no problem.
Sir, মানে
In Assamese you can talk.
হল মানে আমার বরপেটাত একটা ট্রিবিউনাল আছে, তাতে আমি এভিডেন্স সাবমিট মানে ক্রস করে, মানে আমি যিমানে প্লি ৰাজি লাগে ট্ৰেইনে কৰা নাই, তেওঁ সেইটো নামানে আৰু তোৰ ইন্টেনশনটো সেইটো তেওঁ বুজি পায় যে অশিক্ষিত মানুহে বেছি তেওঁলোকে ভালকে ক'ব নোৱাৰিব, মানে সেই এডভান্টেজটো তেওঁ লৈ মানে এনেকে ক্ৰছ এক্সামিনেশ্যনকে ইয়াৰ কিবা ব্যৱস্থা আছে নেকি, মই সেইটো সুধিছিলো।
না কি কৰে বুলি ক'লে সাদুল্লাহ? যে প্ৰথম দিনাখনে সে আমি এভিডেন্স
ধৰক মই আজি এভিডেন্স ইন চিফ DW1 বা DW2 আজি মই সাবমিট কৰিলো, OP বা উইটনেছক মেম্বাৰজনে সিদিনাই লগে লগে ক্ৰছ কৰিব, টাইম নিদিয়ে মানে।
ঠিক আছে,
মেম্বাৰজনে বুজি পায় আজি ক্ৰছ কৰিলে OP ক'ব নোৱাৰিব, মানে ভালকে ক'ব নোৱাৰিব, সেইটো মেম্বাৰজনেও গম পায় আৰু তেওঁৰ ইন্টেনশনটোৱে সেইটো মানে কেছ বেয়া কৰিব লাগে। এই ক্ষেত্ৰত আমি কি মানে ব্যৱস্থা ল'ব?
সাদুল্লাহ বুজি পাইছো সাদুল্লাহ, আপোনাৰ যিটো প্ৰবলেম আছে, মই ভাবো আদাৰ পাৰ্টিচিপেন্ট কেন আন্ডাৰষ্টেণ্ড ইফ আই স্পিক ইন Assamese, যে ইয়াতে কামৰূপ মেট্ৰটো এইটো প্ৰবলেম আছে, কামৰূপ মেট্ৰটো এইটো প্ৰবলেম আছে। এটা বা দুটা কোৰ্টত কি হয়, যিদিনাখনে আমি এভিডেন্স অন এফিডেভিট আমি চিফটো জমা দিওঁ সেইদিনা ক্ৰছ কৰে, তো সেইটোতো আমি তো কৰি লওঁ। তাৰমানে এইটোৰ কাৰণে আমি কি কৰোঁ, আমি এভিডেন্স দিয়াৰ কাৰণে দুই এটা ডেট আগে লৈ ল'লেও আমি কি কৰোঁ, এভিডেন্সটো যেতিয়া ফাইল কৰোঁ তাৰ আগে আগে আমি ফুল ইনষ্ট্ৰাকশ্যনখিনি কৰি লওঁ, আমি প্ৰিপাৰেশ্যনটো লৈ লওঁ। আপুনি যিটো কৈছে আপুনি এভিডেন্স ফাইল কৰি সাক্ষীক প্ৰিপেয়াৰ কৰি পিছদিনাখন ক্ৰছ কৰাব, আমি কি কৰোঁ যে আমি আগে প্ৰিপেয়াৰ কৰি লওঁ, ৰিটাৰ্ণ ষ্টেটমেণ্ট দিয়াৰ পিছতে আমি ফুল্লি প্ৰিপেয়াৰ কৰি তেওঁক আমি এইখিনি কথা আমি সাক্ষীত লিখিলোঁ, তেনেকে দি দিওঁ। দিয়াৰ পিছত আমি সাক্ষী জমা দিয়াৰ লগে লগে তেওঁলোকে ক্ৰছ কৰে, তেতিয়া ক্ৰছ কৰাৰ পিছত আমি তাৰমানে কেছটো আৰ্গুমেণ্টত ফিক্স হৈ যায়। এইটো ট্ৰাইব্যুনেল টু ট্ৰাইব্যুনেল ভেৰি কৰে সেইটো ঠিক সেইটোৰ কাৰণে এটা বুদ্ধিয়ে আছে সেইটো আমি কোনো চেঞ্জ কৰিব নোৱাৰো বিকজ 3C3 কৈ আছে যে ট্ৰাইব্যুনেল কেন ফৰ্মুলেট ইন ইটস ওন প্ৰচিডিং যদি কিছুমান ট্ৰাইব্যুনেলে চিট দিয়াত 3 দিন 4 দিন পিছত লয় কিছুমানে একমাহ পিছত লয় কিছুমানে সেইদিনাই লয় সো যিবিলাক ট্ৰাইব্যুনেলে সেইদিনাখনে লয় সেইটোৰ কাৰণে আমি প্ৰিপাৰেচনটো আমি আগৰ পৰাই ল'ব লাগিব আগৰ পৰাই লৈ ক্লিয়াৰ কৰি যেতিয়া দেখা পাম যে প্ৰচিডিং একদম ৰেডি হৈ গৈছে তেতিয়া আমি এভিডেন্সটো সাবমিট কৰি সেইদিনাই কৰাই দিম দুটা বা তিনটা সাক্ষী যিটো দিম অফিচিয়েলৰ কাৰণে আমি সিদিনা আমি প্ৰেয়াৰ দিম পিছত আমি অফিচিয়েল এক্সামিন কৰিম এইটো আৰু বেলেগ বুদ্ধি তেনেকে নাই আমি তেনেকে কৰিব লাগিব মই নিজেও কৰি আছো তেনেকে
ঠিক আছে
I think
থ্যাংক ইউ স্যার
Sadullah is clear.
ইয়েস ইয়েস থ্যাংক ইউ স্যার
You
Thank
take
you.
the preparation earlier. Yes, Abdul.
ওকে স্যার
Thank you, Advocate Sadullah. Thank you, Zakir, for answering this question. So we have one more question in the chat box. So we have Advocate D. Day, who is asking why the tribunal follows the Foreigner Tribunal Order of 1964, but not the Foreigner Tribunal for Assam Order of 2006.
No, actually, this 2006 order was repealed. Actually, was challenged. 6 and 12 was challenged actually before the Honorable Supreme Court in Sarvananda Sunal 2 case, I think. So the 2 case reiterated about the implementation of the 64 order. So 6 says 6 imposes some burden on the prosecution also, some initial burden. So that was challenged to why this should be, and this is like IMDT. So this provision was again challenged, and the Supreme Court has actually directed for the implementation of 64, as I know. So 64 is there. So under 64, the prosecution or the police has no initial burden to discharge here, nothing to do. The entire burden rests on the prosecutor. So 64 is now in practice. Thank you, sir. Yes, any more questions?
Thank you, sir. Do we have any more questions that anyone would like to ask? You can raise your hand or put it in the chat box. Yeah, Advocate MD Asghar Ali, sir, you can unmute yourself.
I am putting one more question. Sorry, sir.
Yes. Yes.
Yes, sir. Actually, once
Yes.
in my case, sir, once the opposite party has been declared foreigner by the Foreigner Tribunal, thereafter the opposite party has not been arrested and sent to detention center, has not been arrested, and he used to stay at his residential address.
Yes.
He used to stay at his residential address. After passing
Maybe.
after 5 to 6 years, one more case under Passport Act was initiated. Passport Act, sir. In the Passport Act, the FIR contents reads as one foreigner declared person is residing at such and such place, hiding and absconding himself. So my question is, sir, when the FIR itself says that one foreigner declared person is staying, that means citing the order date and along with the copy of order while holding the opinion of the order, which itself is the authority of law to arrest the accused person. Foreigner order is itself the authority of law which gives power to the IO, investigating officer, to arrest the accused person. Then initiating another case basing the same issue under Passport Act, is it permissible in law?
No. See, if the person is declared a foreigner and he has no right to actually live a life of an Indian citizen, and under law generally he is arrested and deported and detained. Deportation is not done, and I think he has not approached the Honorable High Court also, and he should first approach the Honorable High Court if he intends to challenge the order if he is a bona fide Indian citizen. And now, regarding the institution of another case or initiation of another proceeding that is under Passport Act, any affair, that can be done by the police. So there we have to do nothing because he is a foreigner already declared. A foreigner is hiding. As per their police record, he is a foreigner, and they have some allegation from any corner that this person is a foreigner. And if a foreigner is staying in India or Assam without any passport, he may be arrested or he may be prosecuted under the Passport Act. So I do not think this will change any status of this person. I do not think anything. You will have to face consequences. If he is disturbed or actually aggrieved by the order, he should challenge it before the Honorable High Court. So the Passport Act matter is not connected with this the present discussion, I think, regarding the FT. So that is a criminal case filed by the police in violation of Passport Act. And here we are dealing with the Foreigner Tribunal case. So he will have to face the consequences. Ultimately, some other things will come. His name will be deleted, ration card will be deleted, etc., etc. All these things will be done. So I would like to advise that person, if he has some document or if he has some proof that he is an Indian citizen, he should now also he can approach the Honorable High Court and actually fighting that the subsequent proceeding in the Passport Act. Okay, Mr. Asgar.
Okay, thank you, sir. Thank you, sir.
Thank you, Advocate Asgar. Thank you, Zakir. We have another question from Advocate Riaz Khan in the chat. Advocate Riaz Khan is asking that whether the Foreigners Act fails under the test of Article 13 of the Indian Constitution.
Before Zakir comes in, I can quickly share that at Parichay, we are working on preparing a detailed report analyzing this very question, the constitutionality of the Foreigners Act, Foreigner Tribunals order, assessing it and having various experts also give their opinion on this, particularly on the issue of natural justice and fairness of procedure. So those two criteria are being analyzed. So we will be very, very happy to publish the report in the coming months, and that will contain a very detailed analysis on this issue. Over to Zakir, if you want to add something on the constitutionality of the Foreigners Act.
Hello, Rupali.
Yes, yes.
Hello.
We can hear you.
Any problem?
We can hear you, Zakir. The question was on the constitutionality of the Foreigners Act. So can you hear me? We can hear you. We are actually also approaching, we're also approaching 8 p.m. So we should probably take, I think Advocate Zakir Hussain is having some issues with his internet.
Yes, sir.
Yes, you can hear us now, Zakir?
Yes, I'm hearing you. Okay. I'm getting you.
Okay. So the question was quite a long question, which is why I said as a preface that we are preparing a detailed analysis on this, but the question was on the constitutionality of the Foreigners Act and all of this process. So I said that we are actually getting various experts to prepare an analysis on this, and we'll be publishing a report on that. But if there's anything you want to share immediately about the constitutionality of the Foreigners Act, there's a question.
Bali, on this issue, various matters have already been filed before the Honorable Supreme Court regarding the Sarbananda Sonowal case, the Sarbananda Sonowal 1 and 2, and thereafter also in some other cases, the other cases, which cases, so actually going to the Supreme Court from the High Court. In all these cases, this the constitutionality is involved. And now, as lots of cases are pending before the Honorable Supreme Court, Apex Court, I do not think it fit to make any comment on this issue, because actually whatever the law has given to us, provided to us, and what is in practice now prevalent as per the law of the land, and we should go by the law and try to do our best under this system. On the constitutionality, the validity, etc. Mr. Sikdar, our senior, has already told yesterday that this is actually pre-independence law. This law, in practice, in reality, if we see in the real perspectives, in the present context, is not applicable to the person who are the sons of the soil of India. Due to division, someone has gone to, say, Bangladesh, some to Pakistan, some to Nepal, or like this. But all are from this soil. All are interconnected. But this law was for the Commonwealth country and the colonial era. So this was for regulating the movement of the other foreigners. So that law of 46 is still continuing. So I also doubt. I also have serious doubt regarding the constitutional validity of these things. But as this matter is pending before the Honorable Supreme Court to various cases, I cannot make any specific comment on it. But I wish that this act be repealed, because this is a dangerous legislation. And the Foreigners Tribunal order is also incomplete one, which does not lay down the clear rules and regulations for fighting case of the litigants. Yes, Rupali.
Thank you, Zakir, for that answer. And thank you, Rupali, for coming in the beginning. Since we're running out, and we already have run out of time, we'd be taking one last question before we proceed to end the session. We have a question in the chat box from Advocate Judy Gogoi. And Sir Advocate Judy Gogoi is asking whether there is any limitation period for moving the High Court if a person is declared a foreigner by the Foreigner Tribunal.
Yes, Gogoi. Thank you for the question, Julie Gogoi. Actually, under the in the writ jurisdiction, the cases of the Foreigners Tribunal, which we are fighting here under writ jurisdiction, here in writ jurisdiction, there is no such time limit as in case of other civil cases and criminal cases. There is time bar limitation, etc. But herein, one principle is there, that you will have to approach the court within some reasonable period of time. So the non-mentioning of any limitation clause in the High Court's order or the High Court's rules, we cannot wait for indefinite period. And actually, to be wise, if we approach the Honorable High Court immediately after the passing of the order. But in some cases, we have found that the litigants remain, the proceeding remain unaware about the result of the case due to lack of communication and contact with the concerned lawyer, or due to poverty, or due to lack of financial support and legal aid, etc. They remain in their places, hiding from the police, thinking that they will never be apprehended by police or never be sent to the detention center, and finally they face the consequences. In such cases, we have actually fought for the litigants who have come to the High Court even after 15 or 16 years, and we have been able to get some relief, some stay on the order, interim order we have been able to get from the Court of Honorable Justice N.K. Singh, and he has given some specific direction for contesting the cases, provided we show sufficient cause and reason for not approaching the court within actually reasonable time. So we cannot make indefinite delay, and it is wise. And I advise every person, whoever is actually facing adverse situation or has been declared a foreigner or have got some unfavorable order, should immediately approach the Honorable High Court.
Thank you.
There should not be any delay, because in case of delay, the High Court lawyers are facing great troubles in preparing the causes, because the court is ready to condone, provided we show just and reasonable ground and cause.
Thank you.
Yes. I think Julie Gogoi has got her answer.
Yes, sir. Thank you,
Julie
sir.
Gogoi.
Yes, thank you.
Yeah, there is no time limit. Actually, there is no time limit, and it is wise for us. It is prudent, best for us if we approach immediately. But if there is delay, you don't worry. You place explanation. You give them proper explanation and approach the Honorable High Court. You will get some relief. Thank you.
Hello, sir.
Thank you.
Hello.
Yes, yes.
Sir, I have a question.
Yes.
That one person who has not his father's document, as his father was died before enlisting his name in the voter list, and he also died during
Key is it? Hello?
Hello, sir. Sorry, I think there's some disturbance, but we've muted
Yes,
the
there is
person.
some disturbance.
Hello, sir.
Yes.
Sir, actually, when his father has no any document, and moreover, sir, his father has.
Have you tried turning it off and on again?
Hello.
Yes. I think there is some problem in some network.
And his father was also went at the homestead of his wife, and out of their wedlock a child was born, and he and accordingly his name is enlisted in the voter list against his mother. And in that respect, Foreigners Tribunal has sent a notice to him. Then what shall I do for him in support of his father's documents, sir?
Actually, when you were placing your question, there was some disturbance of the background, I think. So I cannot get the full question. However, I have, yes. Actually, however, I have, yes.
A person whose father's name have not been enlisted in the voter list, and his name and he has got married with one woman, and he also stayed at the woman's house, and out of their wedlock a child was born. And he was, and his name is enlisted in the voter list against and in place of his guardian, his mother's name is enlisted. And now notice has forwarded to him, and there has no any document of his father. In that respect, what shall I do, sir?
No. Actually, it is not mandatory that only the father's document can come to your rescue, and you can establish your linkage through your mother also. You can. The Citizenship Act says that the any of the parents should be of Indian origin. Any of the parents should be of Indian origin. If your father has no document, at least some document, then if you try, can find out. But at the initial stage, if the proceeding says that there is nothing in his father's name, then the proceeding can go for the documents of his mother as well as the maternal grandparents also, including the NRC of 1951 and other documents or land documents, etc. And his mother, through his mother, he can establish his citizenship. There is no problem, I think, if his mother has any document. If his mother has no document, then there will be some real problem. And
His mother has documents, sir.
Then through mother you can easily establish. There is no bar. There is no bar that there is no hard and fast rule that you should establish your linkage only through your father. You can establish your linkage through your mother also. If she is your biological mother, there is no problem. There should be clear statement regarding it. There should be clear statement that she is your biological mother and your maternal grandfather is so and so, so and so. And from your maternal grandfather, grandparents, you can actually draw your lineage. No problem. You can do in this way.
Okay, sir.
And yes. Thank you.
Thank you so much, Zakir. So we will be proceeding to end the session at this point since we've already crossed 8 o'clock, the limit. We thank everyone who has attended this session and for sending in all of these questions enthusiastically. We will also be having 2 sessions next week, which will be about at the same time on Saturday 6 to 8 p.m. and on Sunday 6 to 8 p.m. The Saturday session will be on proving linkage without documentary evidence, and the Sunday session will be on final arguments. We urge everyone to join in, and we shall be sharing the details of the documents that we've shared today with all of you on email. So stay tuned for that. I will be passing over to my colleague Sita, who's a core team member at Parichay, to give the vote of thanks now.
Good evening, everyone. It is my pleasure to deliver the vote of thanks today as we wrap up the second session of our lecture series on Foreigners Tribunal practices. We at Parichay would like to thank all the dignitaries, speakers, and lawyers who have participated in the session. We would like to express our profound gratitude to His Lordship, the Honorable Justice and Kotiswar Singh, for his generous and continued support to this initiative. We truly appreciate it, sir. We also sincerely thank Advocate Zakir Hussain for conducting this session and for sharing with such sensitivity his extensive experience in this field. I'm sure that it has greatly expanded our understanding of the complex issues that arise while contesting cases in the Foreigners Tribunals. We would also like to thank the Assam State Legal Services Authority for collaborating with Parichay and the member secretaries of ASALSA for their presence in both the sessions that we've held so far. We would like to thank particularly Shri Nayan Barwa, member secretary of the ASALSA, for his vital support in organizing this series. We want to extend our gratitude to Shri Tipti Ari, the Deputy Secretary of ASALSA, and Shri Aishri Shravan of the ASALSA for their generous and proactive support. We are grateful to Shri Aishri Shravan ma'am for her presence in the session today as well. We want to thank Darshana Mitra, Rupali Samuel, and Shadul Gupushkar from Parichay for moderating this session. Lastly, we express our heartfelt thanks for your interest in attending the program, and we hope to see you soon in the coming weeks for the next sessions. And lastly, the Google form that has been shared, please fill your details so that we can share the copy of the judgments. And we'll also be sharing the YouTube link so that you can watch or rewatch the sessions. And thank you once again for attending. Thank you.
Thank you.